Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Let's turn briefly to a preview of what we might or might not get from the Supreme Court later this week. The justices are expected to hand down opinions tomorrow, Thursday, and possibly also on Friday as they eye their annual summer break with many big cases, big opinions, big decisions still outstanding. Kate, I'm wondering if there's any on this list that stick out to you as a particularly interesting case to be watching for.
I mean, I think the obvious one everyone is watching is presidential immunity. I mean, Jack Smith has been arguing that Donald Trump is no more immune than anybody else. And I think that argument has real consequences for the future of the executive. So we've been encouraging the court to take its time to try to find the right balance that allows presidents to be held accountable for true crimes without criminalizing every action they might take while in office and making it political prosecutions more likely to be a norm. There has been so much pressure on the court to go quickly and come to an outcome here, but it could kick this back to lower courts. And I think it would be appropriate to follow the normal process and not be on Jack Smith's timeline to try to get some sort of result here before the election. Real quick, also, we're waiting on a decision in the case involving January 6 convictions and a particular Sarbanes-Oxley, the financial regulation law enhancement that basically trumped up some of these charges to obstructing a proceeding in a certain way that basically the government argued that a really expansive definition of this that I don't think was intended to cover the bad behavior that occurred on January 6th. So you had at the D.C. Court of Appeals, the government won, but you had a very vigorous dissent from Katsas, who basically said the interpretation that stands would allow basically all sorts of minor offenses to be trumped up into felonies. So I think that is a really consequential case. And the outcome of it really matters because there's been a lot of political polarization over January 6th. You have people claiming absurdly that January 6th defendants are political hostages. But on the other side, you want to make sure that they're treated fairly and in accordance with the laws and with what other lawbreakers of other partisan backgrounds would be treated. So those are the two that I think I'm watching closely.
I'll say a word about a couple of gun cases. The first is Garland v. Cargill. That's about bump stocks, these accessories that some gun owners use to enable rapid firing by pushing the gun forward. The gun slides back and forth then against the trigger finger. And the administrative state, the Bureau of Alcohol, Tobacco, and Firearms, in 2018 issued a regulation to clarify that bump stocks qualify as machine guns. So this is not exactly a Second Amendment case. It's one of those cases about who gets to decide, because the federal law, to my eye, is pretty clear that the definition of machine gun is a gun that automatically fires more than one shot, quote, by a single function of the trigger, unquote. And so it seems to me that the law here is pretty clear that bump stocks are not machine guns. And so ban them or don't ban them, but do it the right way. And that has to be done, I expect the Supreme Court will say, by Congress or by states, not by some sort of redefining the terms that are in the federal law. The second case is Rahimi, U.S. versus Rahimi. This is a Second Amendment case following the new test that the Supreme Court laid out by Justice Clarence Thomas in the recent Bruin opinion, saying that gun regulations have to be consistent with America's historical tradition of firearms regulation. And so the question here is domestic violence restraining orders. Zaki Rahimi is the person involved in the case, and his conduct, it makes it clear that he should not have a gun, to my eye. But the question is, what is the right way to disarm someone like that? Do you have to convict them of a felony? Does this kind of civil state restraining order work? And there could be some middle ground. There's some Second Amendment advocates who argued to the court in a brief that as long as a judge in a civil process is finding the person to be a credible threat, that might satisfy the Second Amendment standard. So it's not clear to me exactly how the Supreme Court will decide this case, but it will be the first in what I'm sure is a series of cases, putting some more meat on the bones of how this Bruin test is exactly supposed to operate. And Kim, we'll give you the last word. What are you looking for?
Okay. Mine aren't nearly as sexy as your guys's with your sedition and your guns but I'm just a wonk. So I'm actually most focused on and excited to see what the fate of the Chevron doctrine is going to be. This really is a wonky issue, but hugely important for the country. So the Chevron doctrine is a longstanding court doctrine that holds that judges must defer to regulators when statutes are ambiguous, sort of based on the idea that the regulators have all the expertise. This has been a deadly doctrine, I think, for the U.S. and the size and scope of the administrative state. It's created a turbocharged bureaucracy that runs Mack trucks through the law at every opportunity they get. It's created a very lazy Congress, which often doesn't get very specific in its legislation, sometimes very purposefully. Democrats in particular love to write vague statutes because they are banking that while they can't get those provisions specifically through Congress, that the regulators will pick up the areas of silence and create those laws for them. I think it's created for lazy courts as well that have decided that instead of really engaging in judicial review, that they will simply defer to those bureaucrats. So this involves a pair of cases that have to do with a Trump-era regulation in which a Commerce Department claimed that it had the authority to require herring boat operators to have government-named monitors on their boats and to pay for those monitors. And the rule claims it has that authority because the law tells them that doesn't say that it can't do that. And while there's a possibility that the court might only rule on the question of this rule narrowly, some people are very hopeful and optimistic that it could be a curtailing or a demise of Chevron, and I am among those people. Last one, quickly, it has to do with the issue of homelessness. And my home state of Oregon, the city of Grants Pass, like many cities, has a law banning public camping. There was a class action launched by homeless groups that claimed that such statutes are a violation of the Eighth Amendment's ban on cruel and unusual punishment. I find this absolutely absurd. Listening to the oral arguments at the Supreme Court, it felt as though many of the justices did as well, too. I think if we were to allow this to stand, the list of issues that could be ushered under the umbrella of what counted as cruel and unusual punishment would be limitless. So I am hopeful the court puts an end to this quickly.
Thank you, Kim and Kate. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.